As part of a series of hot legal topics for 2021, I'm talking to Russell Conway about hot legal issues in landlord and tenant law. We're going to discuss 5 issues: the ongoing ban on evictions, what's happening with cladding in 2021, gas safety certificates and Section 21 notices, the increasing reluctance of landlords to grant consent for alterations, and the difficulties faced by people renting out their properties on AirBnB or similar sites. Hello, I'm joined by Russell Conway, who's been an expert in landlord and tenant law for over 40 years. He's a partner at Oliver Fisher Solicitors in Notting Hill, where the firm is currently working for survivors of the Grenfell Tower fire at the public inquiry. Until recently, Russell sat on the Law Society Housing Committee, and he's a regular contributor on LBC Radio. Russell, one of the big issues for 2021 is the current ban on evictions of tenants. Can you explain a little more about that?
Well, 2020 was, of course, the year of COVID, and the last thing the government wanted was lots of tenants who couldn't afford their rent being evicted onto the streets. And the Coronavirus Act 2020 provided a stay on all possession proceedings from the 26th of March last year until the 28th of August last year. Now, that stopped court proceedings from proceeding in the courts, but there were still people being evicted, and so the government put a complete ban, a blanket ban on evictions. Originally that was going to end on the 11th of January this year, but considerable pressure was put on the government to extend that because we're still living with the virus and people are still out of work and unable to pay their rent. And so that ban on evictions has now been extended until the 21st of February, which is a good thing because nobody wants people evicted from their homes, put on the street, or having to attend at local authorities to somehow get homelessness accommodation. However, what happens on the 21st of February? Who knows?
Does this apply to business properties as well, or is it just residential properties?
The business situation is completely different. The government, from a very early stage, stopped all commercial premises from being in a position where they could be thrown out for not paying their rent, and the ban on commercial evictions goes on until April this year. Now, again, that's a problem for commercial landlords because some of their tenants aren't paying their rent. But equally, there are a lot of commercial tenants who have no way of paying their rent, so that's a good thing.
Looking forward, if the ban does end in February, what's going to happen? Will people just be thrown out their homes, or is there some sort of court process which means it's going to take time to evict people?
No, people will not be thrown out the next day. There's a 14-day process to apply for a bailiff's warrant, so nothing's effectively going to happen until sometime in March.
In a moment, I'm going to ask you, Russell, if you think there's a likelihood of the government extending the current ban on evictions. Before I do, if you like this video, would you mind just clicking the like button underneath? It helps other people find the video, and it's thanking Russell for the fact that he's volunteered his time to answer these questions. Russell, over to you.
I think that the ban on evictions is likely to be extended because this virus isn't going anywhere at the moment. It's still with us. It's very much something that will be with us, I suspect, until later in the year. While the virus is with us and lockdown is with us, people aren't able to earn money. They're not all able to pay their rent, and there are problems. I think the very last thing any competent government would wish for is large numbers of people being made homeless. And for instance, some governments have, the government of Hungary, for example, have done a 2-year ban on evictions, which surprised me. And I had a look at the Hungarian legislation, but they have actually legislated for a ban on all evictions for 2 years.
In 2017, we had the Grenfell fire, and the Grenfell fire inquiry isn't likely to report till 2022 at the earliest. What are the issues regarding cladding in 2021?
Well, in December 2019, the Royal Institution of Chartered Surveyors and the various lending organisations met to discuss the cladding issues. Because remember, mortgage companies and banks lending on properties don't want to lend on a property where if the mortgage payments aren't paid, they can't sell because of problems with cladding. So in December 2019, they decided that anyone applying for a mortgage on a property over 18 metres or with cladding would have to provide something called an EWS1 form, External Wall System 1 form. Now, the problem with that form is that it's a form that can only be completed by a chartered fire engineer, and there are only about 250 chartered fire engineers in the whole of the United Kingdom. So a lot of work for those guys, but not enough people to do the work.
Is it a widespread problem?
After Grenfell, it became aware that Grenfell was not a one-off. There are literally thousands of buildings with Grenfell-type cladding or Grenfell-type problems.
Just explain the impact of all of this.
The problem we've had during 2020, and which is continuing in 2021, is that people can't sell their properties because nobody will buy them because there aren't enough EWS1 forms being completed. If EWS1 forms are completed and there is a need for remediation work, taking off cladding, repairing wooden fascias, that sort of thing, the leaseholders aren't able to pay for it. Some leaseholders are already receiving service charge bills for 60,000 quid. They can't pay for it.
Russell Conway, what do you think the solution is?
Last year they put forward a fund of 1.6 million to help leaseholders, but that's far, far too low. Anyone looking at this and doing the figures will come up with a figure closer to 16 to 20 billion. And the government really needs to find that money because the problem is of the government's making. The building regulations which the government drafted are so obscure and so difficult to understand that people have managed to put this flammable cladding up on buildings.
If my next door neighbour sells their flat and gets an EWS1 form and it's all okay and the mortgage application goes through, and then I want to sell my flat, do I need to get my own separate EWS1 form, or will the neighbour's EWS1 form cover the entire block?
No, the EWS1 form covers the whole block. It covers every aspect of that block: cladding, balconies, sometimes fire doors, fire gapping within insulation. It covers the whole building. Now that's one of the problems, because if you're a chartered fire engineer and you're looking at a building which is 10 floors high with 30 people living in it, that's quite a lot of work to do, because it's not one of these old style surveys where you come round and have a look and write a report. A lot of these involve invasive analysis, drill analysis, taking core samples and removing cladding to test it. It's quite a big deal. It's not just a short test. It's not just a visit for a couple of hours. To get an EWS1 form takes a lot of time and effort.
What's your prediction as to what the government is going to do this year?
I think the government realises there's a significant problem here. I think it also realises that if Joe Bloggs buys a flat in a building with cladding on it, it wasn't his fault. When he bought that flat, say 5 years ago, his surveyor would have been blissfully unaware of the problems. The problems of cladding only came out after the dreadful Grenfell fire in June 2017. And it's not an individual leaseholder's fault what is happening. And for that very reason, the government is going to have to step in. They already have done. There is this fund of 1.6 billion, which sounds a lot, but it really isn't, because when you're stripping off all the cladding from a building, putting new cladding on that building, perhaps having to move all the residents out while that work takes place, that costs a fortune. But the problem lies at the door of the building regulations. That's why the government has to help.
On hot issue number 3, can you start by explaining what a gas safety certificate is and what a Section 21 notice is?
Assured short-hold tenants can be evicted by their landlord if they serve a Section 21 notice. It's what we often refer to as a no-fault notice. The tenant can be up to date with his rent, he can be a perfect tenant, but if his contract has come to an end and the landlord wants to get rid of him, he can serve a Section 21 notice. And a lot of tenants find that quite unreasonable, because if you've paid your rent and you've been a good tenant, you may wish to remain on the premises. However, there are certain restrictions on serving a Section 21 notice. One of those restrictions is that you can't serve the notice if you're a landlord unless you have an up-to-date gas safety certificate. And that's an important certificate. It shows that all the gas facilities in that flat are safe. It shows that the boiler is safe, it's not leaking carbon monoxide fumes. It shows that the fires and the cooker are safe. And it links very much into the current sort of post-Grenfell feeling that properties that tenants live in should be safe.
I believe there's been a recent change in the law that affects how gas safety certificates and Section 21 notices interact together in 2021.
Yes, in June 2020, the case of Trickarol House and Rounsfield was decided. It was one of my cases. And the court said that as long as the gas safety certificate was served by the landlord before the service of the Section 21 notice, that was okay. Previously, the authorities had said that the gas safety certificate had to be served on the tenant before they moved into the property. And there was a leading authority, Caridon Properties and Shooltz, which was decided by His Honour Judge Luber in the Central London County Court, which said if a landlord has not served the notice prior to the tenant moving into the property, they could not serve a Section 21 notice. Now, landlords were very pleased with Trickarol House and Rounsfield, although I am at liberty to say that I'm trying to take that matter to the Supreme Court.
Just explain then what the practical difference is now for landlords in terms of getting a valid Section 21 notice served on tenants.
It's now easier for landlords to get a Section 21 notice because they can serve a gas safety certificate on the 1st of February, and on the 2nd of February they can serve the Section 21 notice, even if they had not given the notice before the tenant moved in.
If you're successful in getting permission from the Supreme Court to appeal, do you think the appeal is going to be held in 2021, or will it not be until 2022?
I guess it won't be heard this year because it's not an emergency matter, but I think it would be heard either very late this year or early next year. And remember, Trickarol House and Rounsfield was decided in the Court of Appeal only by a 2-to-1 majority. So there was a dissenting judgment.
The fourth hot issue I'd like to discuss with you, Russell Conway, is the increasing reluctance of landlords to grant consent for alterations. What's the position on that?
Landlords generally have a lease which says you can't do alterations to your property without the landlord's consent. Now, there are two types of clause. It can be a clause which says that consent can't be unreasonably withheld, or there can be an absolute prohibition. However, landlords quite often go ahead with a consent and give a licence for alterations, but in the case of Duval and Randolph Crescent, they reckoned without Mr. Duval, who was another leaseholder in a building, and when he heard about one of his neighbours doing substantial structural work within the building, he said to the freeholder, there's an absolute prohibition on consent to this type of work, you can't give that consent. And that case went through the Court of Appeal and ended up in the Supreme Court last year, and the Supreme Court agreed with Mr. Duval and said that if there is an absolute prohibition on giving consent to this type of work, the freeholder may not give that consent, and so the neighbour couldn't do his major structural works.
What ramifications does that case have going forward?
This case has major ramifications. Leases have all kinds of absolute prohibition. An absolute prohibition on keeping pets. An absolute prohibition on putting a wooden floor into your flat. Recently, people have been rather relaxed about this, and a lot of freeholders, given a request for somebody to have a Labrador or a cat, will simply give them permission. Likewise, if somebody wants to put a good quality hardwood floor down with insulation, freeholders have generally agreed to that. perhaps with a small premium or payment of costs, etc. But in the future, I think a lot of freeholders, given the case of Duval, are going to look very carefully at whether they can do that, because if they get involved in litigation with other leaseholders, that could cost the freeholder a lot of money, and that's money they may not have.
So in one sentence, can you explain how the approach to landlords when it comes to granting consent for alterations is likely to change in 2021?
In 2021, landlords are going to be much more cautious about granting consent for alterations, for pets, for wooden floors, perhaps even for subletting, because until Duval, which is a Supreme Court case, and we're stuck with it, freeholders took the view that they could perhaps break the rules or bend the rules in their favour. But in the future, that's not going to happen. And I think a lot of freeholders, faced with requests for consent, are going to decline those requests.
The fifth and final hot issue is the position of short-term lets and Airbnb type sites. What's the issue that leaseholders need to be aware of in 2021?
Yes, Airbnb is a comparatively new beastie, but it's been with us for a few years, and a lot of leaseholders are letting out their premises on Airbnb. And in many cases, they're simply not able to do so because the large majority of leases have a very straightforward clause saying that the property should be used for single family occupation or a single dwelling house for the use of a family. And virtually every lease I've seen contains that clause. They also go on to say that the property mustn't be used for business use. Now, last year in a case called Triple Rose and Beattie, this was considered by a housing court, the upper tribunal, which is the appeal court from the first tier tribunal, and the court decided that somebody letting out their home on Airbnb wasn't using that property as a single family dwelling. People using their flats for Airbnb do have a lot of problems which they're generally blissfully unaware of.
Can you give some examples?
They have insurance and they don't tell their insurers that somebody else is living there, so their insurance becomes invalid. They quite often have a residential mortgage and they don't tell their mortgage provider that they're letting the premises, which can cause some problems with their mortgage provider. But increasingly, freeholders are becoming involved. They don't want large numbers of people coming to their properties, having parties, celebrating their visit to the United Kingdom, and perhaps disturbing their neighbours. And I think 2021 may be the year where we see freeholders really cracking down on leaseholders using Airbnb type sites.
Thank you to Russell Conway of Oliver Fisher Solicitors. You can find his contact details in the notes below, along with links to some of the cases that he's mentioned. If you found this video useful, please do subscribe. You might also want to look at my other hot topics for 2021 videos, which you can see here. You might also like this video. Thank you so much for watching. I'm Daniel Barnett. Bye-bye.